Oh my Ghana mu haseya me no ka say enrada na ye de update bi eba ye say former Maslock CEO Mame Sedina Tamakloe ationu extradition plea ye de call US no US for agya to mu adi so amanda me no ka say de wa bepie mu e wo Ghana ha na pia wa bepie mu wo Ghana ha no ye nyina ye nim se wo ba be serve ne 10 years ye de no judgment of 10 years in absentia no oni ho ene serve no sa 10 years no enti obedru ye no ebeto dwa se prisons ene Ghana Police Service for akwakotebirina wo mo ye the necessary process wo me de befa so se de be ya obekwa kopie mu e wo prison na wako serve ne 10 years no immediately but another sorry ya update eba no that screens no say ex Maslock's boss Sedina Tamakloe ationu 6 Court of Appeal to overturn 10-year conviction inti na chese wono a obaye ya penache 2024 nsem ne sha say man who verdict close to 2 years now obeba o mada US for aboaye mama mi abepie mu Ghana no obaya chese wono edwane akọ Court of Appeal se atembu a omubu ye no wo mo enani asem no no mo nhwe na omunye bibi enfamfa the issue ni ho na akose a lot of reactions amanfo chem se ne ha wokrapo de nka ye ka nke wo se wo kebi kra Kelsi ye ubaye na prison for any police for tebri na no waye din no akọ serve or sentence no because looking at it no ohun cry bufu kra dada according to some Ghanaians ye case e na aka che se okosiki medical attention aba wa mabie ma ye beba obeba wa man ye di asem ni wie ye pass a verdict in your absence ubaya wedwane Echo Court of Appeal said they should overturn the issue. Now let's delve more into the issue. What say and some there it's a whole lot until as you can see also ex Maslock boss Sedina ationu appeals 10-year sentence inti ono ejemu a yenye bribi enfamfa ne 10-year sentence ye de amano no ehun na from all indication no he feels like something needs to be done about it. Now say former chief executive of Ghana's Microfinance and Small Loans Center Maslock Sedina Tamakloe ationu has asked the Court of Appeal to overturn her conviction and 10-year prison sentence. And ne krakra no na chese mami ye de kwadu bebre abono money laundering, embezzlement, causing financial loss to the state. Any ade ni nyina ye gina so abone charge ni ya sentencing to 10 years no or say Court of Appeal enhwe ensem no omo nane sa 10 years sentence no. She argues that the charges brought against her were legally defective and violated her constitutional rights to a fair trial. International chemwa kwadru ni ade abobo no sebe mbremu no nanke wo se ono nso yetimi di asem no pepepepepepepe sebe eniema bia there will be no defect on it and as bibi but kwan omofa so di asem no enhyeda emfa emrakwan so that is what Mame Sedina eka. Now say in a report by GhanaWeb.com, the appeal submission filed in February, Tamakloe Ationu's lawyers challenged a 2024 High Court judgment that convicted her on multiple counts including stealing, causing financial loss to the state, money laundering, improper payment of public funds, and breaches of public procurement laws. And to omuchema before Mame ni bedru Ghana krano, and the lawyers for etebri krata edekwa appeals court say momoko akwa appeali the 10-year sentence ayede amano no. Now 2024 High Court judge pass sentence of 10 years man based on kwadu ayede abobo no stealing ka ho na say wawia ade wabo oman ka that is causing financial loss to the state, money laundering, so improper payment of public funds and say sika bia eni kwan se mami etua no wakotua eni ade a ye chemu se emra bi wo hokra ebra na all serve as the CEO no wabusa emra no esho. Now see the former Maslock boss contends that several charges lacked sufficient particulars and merely repeated the wording of relevant statutes without clearly outlining the specific act she was alleged to have committed. Into no person or chere say kwadro e de aboboni na bebre ho no ma sebe eni ngina so bibie ni wa chere say ade aye chere say waye no we ena chere say indeed mami we boni we e di susu na kwadro e de bono no no kre say waye anase wonye ye enti ojema case no mudi ye no omo ndi no ewo in a fair way, because some of the charges that were leveled against her no clearly no na chese shede ni specifics act bia etiano. Now her legal team argues that the omissions breached Article 19 Clause 2D of Ghana's Constitution, which guarantees accused person the right to be informed in detail of nature of the charges against them. And to say no mudi ekombrem. And according to Mame Sedina and the lawyers no, on person mo kire say case na ye di ye no omati ambra. And omati ambra in a sense o share your constitution in Article 19 clause 2D na de chene se mudi kwadu bo bia e wo se mutimi eda na de pefe bie mu e chire mu ye se kwadu na ye de bo no ade we enti ne abo sa kwadu e na etia wo na so mo ntimi an kire sa ade ni mu nyina fa nkire eye ma me Sedina enti wo mo gi sa sentence we tumu a enye yie. Now, say this is an appeal against the judgment of the High Court, delivered on 16th April 2024. The filing states, adding that the conviction should be set aside because alleged procedural and evidentiary shortcomings during the trial. Enti omo tem se kwan omo fa so di asem ne kra no enfomso wo ho enti omo kwa appeal se le be appeal court ebe kasa e de afa judgment a High Court emaye on 16th April 2024 no eho omo se niema bi etosin e wo judgment no eho na omo nsan fra asem ni biem na enye so omo fra asem ni omo asan start process no all over again no motimi prove right say indeed kwadra e de bo maame no odi for ewo ho dia ene enu omu ni hweka ewo ho. Now Tamakloe Ationu and a co-accused Daniel Axim were first arraigned in 2019 over allegations involving the management and disbursement of Matlock funds during her tenure between 2013 and 2017. Inti nipa ba kwa wakama me eye Sedina hono eye Daniel Axim 2019 ene edo mo ekogina court akwadro ede bom ne sika bi afa wo nsem a nanka enwo se eba ne sa ni nyina sa bre no na eye ma me Sedina Ationu ena na eye pani a weda Matlock na no from 2013 to eye 2017. Now, I'll say one of the central allegations concern 500,000 Ghana cedis investment transaction involving Obatampa Microfinance Company Limited. Prosecutors allege that Tamakloe Ationu rejected a fund check and instead requested payment in cash, which was subsequently delivered to her. And Omuchema ni case no bako efa eye wono eni Obatampa Microfinance Company ni ho a sikapudu a namso no eye 500,000 Ghana cedis investment a ye chemu ana chese nka check kra ena na ye de ema maame na maame si da oda omuntua ni in cash enfa enhye ni nsem. Her lawyers, however, argued that prosecutors failed to establish beyond reasonable doubt that she dishonestly appropriated the funds. And the lawyer for Chemwa said the judge and penny for Cassicane a fan and semono, one fine yard the pa ena was say sicano, woman so omuchemu se enyano cre, sa say asemo mokano. They further dispute the authenticity of a key acknowledgement letter relayed upon by the prosecution, insisting that the burden rested on the state to prove authorship of the document. The appeal also challenges findings related to the withdrawal of more than 1.8 million for a nationwide sensitization and monitoring program. Enti sika biema eno nso abemu 1.8 million echem se omuko yi se sika no se omo de be sensitization na monitoring program bi ni ade se sika no so omo anse de hu kwan ye fa so a wodi se sika no. Enti utimi se there've been a lot of cases involving money any ade de abo maami a enu nti asem no court trial severally court after some time no ye ban no the 10-year sentence and never bedru Ghana woche mu say or court appeal akotia the verdict high court apase somewhere in 2024 16th April. So right now there so obi abetimi akọ and the court there wo ho edimo obi anti ono akwaso okosiki appeal. We are just following how event is going to unfold with this particular turn of events, because na yenye nim say odi aye there sentence na or ko serve, but it looks like she's trying to challenge the verdict at this point and no crash here somewhere in February and sana or baby PM e wo Ghana ha. We will still be following this issue near ahwe baby a ebeko akwa kudro updates bi ebeba no e de bebrem now.